Good day. I am Barrister Mrs. Ijeoma Maxiri Lanozie. I'm the principal partner at ICNC Legal Practitioners, which is a leading law firm based in Lagos, Nigeria. And this is the ICNC Law Lecture Series. Today we'll be discussing a topic under commercial law, one which is actually very common or very popular amongst people. Today we'll be discussing suretyship, or what it means to be a guarantor under Nigerian law. First, we begin with the definition. A guarantor or a surety is a person who undertakes to pay the debt of another person in the event that that person fails to pay. So now let's put it in perspective. A guarantor is a person who undertakes to a creditor to pay the debt of another person known as a debtor where that debtor fails to pay. And so that makes the guarantor the secondary debtor who bears the secondary liability. There are, however, some very cogent principles under suretyship or under guarantorship which a lot of people might not know, and they just go ahead to sign the guarantor's form without actually knowing exactly what it entails. So first of which is, as a guarantor, you are not an indemnitor. A guarantor is not supposed to indemnify. What that means under the law is that an indemnitor is a person who undertakes to pay the debt of the debtor where the debtor fails to pay. But in this case, the indemnitor takes the position of that debtor. The indemnitor is as good as the debtor. In fact, it is as good as saying, where this person fails to pay the debt, no need to go after the person, just come after me. That is what indemnity means. And so where you sign a contract of indemnity, or where they tell you that you are a guarantor, but the terms of the contract of guarantee states that where the debtor fails to pay the debt, they would come after you without first going after the debtor. Where it states that they would come after you without first going after the debtor, then that's when it becomes a contract of indemnity. So in a contract of guarantee, they must first of all go after the debtor. Where the debtor has now failed to pay after series of prompting, depending on the terms of the contract, where the debtor has now failed to pay, that's where they come after you, the guarantor, But in a contract of indemnity, they don't even bother to go after the debtor. They just come after you directly once the debtor fails to pay. So if you're going to sign a contract of guarantee, or if you're going to sign as a guarantor, you need to read through the lines of the agreement and be very sure that you are not signing as an indemnitor. Sometimes they even use the words interchangeably. You even find some people using some contracts where they don't mean the same thing. Your liabilities are not the same. The liability of an indemnitor is that of a primary debtor. The liability of an indemnitor is that of a principal liability. He has the primary liability. The second thing you need to know is, for you to say that you are a guarantor, is for you to agree in writing, usually in writing, that you would pay. So it is not enough for you to just sign a form where they say -- guarantor and you just sign. No. Merely by calling you a guarantor may not necessarily imply that you would be the one to pay where the debtor defaults. There's a need for the agreement to also specify that Mr. A guarantees to pay the sum of 10,000 or whatever amount in case of default by Mr. B, who is the debtor. So it is not enough for them to just put a dotted line there and say, oh, sign here as guarantor. That might not suffice under the law. Okay, so if you're a money lender or if you're into the business of loaning, you need to take note of that. Also, under a contract of guarantee, where the main contract is void for one reason or the other, maybe for lack of consent or for illegality, and it offends one of the provisions of the law, it also affects the contract of guarantee, such that if the contract of the main contract between the creditor and the debtor is void, then your own contract contract would also be deemed to be void, because you're expected to redeem the loan which was taken by the debtor. And so if that loan has been voided by the law, definitely your own contract is also void. Also, you need to know that the death or insanity of the guarantor under a contract of guarantee does not necessarily relieve him of the liability to pay the debt, depending on the type of contract of guarantee. A contract of guarantee might be revocable or irrevocable. And so if the contract of guarantee is irrevocable, the death or insanity of the guarantor does not discharge him from liability. He would still have to pay. When there is a variation in the terms of the contract, such as where the both parties, the creditor and the debtor, have agreed to a specific amount as the loan sum, but the creditor remitted an amount that is less or an amount that is more without obtaining the consent of the guarantor, that's a variation to the terms of the contract of guarantee, and that's enough to relieve you of the liability to pay. The law also permits for the contract of guarantee to not cover for the entire loan sum. It may cover just for the interest, it may cover just for the interest, it may cover just for a part of the loan sum, and so a contract of guarantee does not have to cover the entire bulk of the loan. In cases of part payment, the contract of guarantee becomes very, very complex. In cases where the debtor, the principal debtor, is allowed to pay in part, what then happens to the liability of the guarantor? Well, the answer to this question is simply dependent on the agreement between parties. In some cases, parties agree that the part that has been paid for becomes what was guaranteed. I'll give you a practical example. If Mr. A took a loan of 10,000 naira and agreed with the creditor to pay 2,000 every 2 weeks, and he ended up paying 2 installments, which is 4,000, leaving a liability of 6,000. The creditors have tried to reach him severally and have been unable to. The liability then falls on the guarantor, who guaranteed to pay just 4,000 out of the 10,000. So the question now is, the 4,000 that the guarantor has agreed to pay, is it going to be the 4,000 that the principal debtor has paid, or is it going to be the 4,000 out of the 6,000 left? So that is what we're trying to discuss now. This is a very serious issue with regards to contract of guarantee. The loan has to specify whether the 4,000 naira that was guaranteed is the 4,000 that has been paid as part payment, or whether it is the 4,000 left unpaid. The fact that the debtor paid some part of the money before, and that part of the money that he paid is the exact money that you guaranteed, does not necessarily lift the liability off of your shoulders. The contract, I beg your pardon, needs to specify whether that money that you guaranteed is what is going to be equated to the part payment that has been made, or whether it's going to be equated to the money left unpaid. Again, it is necessary for you to know as a guarantor that the mere fact that the debtor, the principal debtor, eventually died or became insane or became of unsound mind, or for whatever reason was no longer in a capacity to pay the debt, mentally capable to pay the debt, does not automatically void the contract he had with the creditor. In fact, that is the reason why you were made a guarantor. And so once the principal debtor is for one reason or the other unable to meet with the payment of the debt, including debt or insanity, the burden still falls on you to repay that debt. Also, you need to know that once the guarantor pays that debt, the guarantor takes the position of the creditor, and then the loan becomes repayable to the guarantor, who is now the creditor. And so the fact that the guarantor has paid the creditor the principal debt that was owed does not mean that the debtor is now free to go without remitting the money, the loan sum. The guarantor is still allowed under the law to go after that debtor and recover that money which he has paid to the creditor, because he's now taking the position of the creditor under the law. And lastly, because the guarantor now takes the position of the creditor under the law, it entitles him to whatever security that the creditor might have collected from the debtor in order to secure the loan. And so the guarantor can now go to the creditor and collect that security, hold it as security for his own loan, which is now between him and the debtor. And that is basic information about suretyship and guarantor under Nigerian law.